Does an oral agreement between two friends and business partners get erased by an amendment of the business documents? To find out, you have to read Baylor versus Tao, but it's 19 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Baylor versus Kai-Shing Tao. The citation for this case is 2025 New York Slip Opinion 00803, published by the New York Court of Appeals on February 13th of 2025. The issue in this case is whether an oral agreement between two friends and business partners is superseded by an amended LLC agreement with a merger clause. I'll explain all that in a few moments. The background that's helpful to understand this case is that under CPLR, Civil Practice Law and Rules 3211A1, a motion to dismiss can be made to a complaint. So if someone files a complaint, the defense can file a motion to dismiss under 3211A1 on the grounds that documentary evidence conclusively establishes a defense as a matter of law. So if there's a case where the claims are actually disputed and can be refuted unambiguously by a document, then the case is subject to dismissal under 3211A1. The facts in this case are that the defendant in this case is Tao. He's the CEO and chairman of the board of Remark Holdings, which is a publicly traded company. And he also owns and controls Digipac, which is an LLC. Digipac is an LLC that he uses to put money into Digipac and then route funds from Digipac to Remark for purposes of funding Remark. Plaintiff, Baylor, is friends with Tao and has been for 20 years or over 20 years. And they often have business and personal relationships with each other. And they often have oral agreements to make business deals, allegedly according to the complaint. Allegedly, this is according to the complaint, in 2012, the defendant, Tao, asked the plaintiff to invest in Remark by putting money in Digipac. Because remember, Digipac is used sort of as like a wallet or a bank account to fund Remark by the defendant. The plaintiff was nervous about this and said, hey, if I'm going to invest in Remark, why don't I invest directly in Remark, not in Digipac first? And to address these concerns, they come up with the terms of this oral agreement, which essentially is that the plaintiff promises to invest $3 million in Digipac, and the defendant promises to allow the defendant to get the money out in one of two ways. Either if Remark hits $50 per share, the defendant would sell to the plaintiff the shares of Remark or pay to the plaintiff that amount of money that he put in, or if the price of Remark never reaches $50 over a 5-year period of time, on the 5th anniversary of the investment, the defendant would pay to plaintiff the value of Digipac's Remark Holdings, whatever that is. Plaintiff agrees and gives $3 million in two different payments, $1.5 million in 2012 and $1.5 million in 2013. And as alleged in the complaint, the defendant never paid the plaintiff back. Okay. Now, Digipac is the sole member of, according to the LLC at Digipac, the sole member of that company is the defendant, Tao. And it gives the sole member of that company the ability to amend the LLC agreement at his sole discretion without any consultation or requirements. So the defendant, Tao, amends Digipac's agreement and says, I'm going to control who I allocate the money to, the business shares. And this, importantly, the amended agreement said it had a merger clause that said any outstanding other agreements are merged into this one. So it does not recognize the viability of any outstanding oral or written agreements that precede the amendment of that LLC agreement. 5 years passed, the defendant never pays the plaintiff, and at that point, under theory number 2 of recovery, the amount of holdings, the amount that the plaintiff would have gotten from Digipac is $11.6 million, because that's the value of the holdings Digipac had in Remark in 2000 and after the 5-year period of time. The plaintiff then sued the defendant, saying, we had a personal agreement. You and me, person to person as friends, we had a personal agreement. And so he sues him under his personal capacity, not under his capacity as chairman of the board, under his capacity as leader of Remark, breach of contract, breach of the oral agreement. The defendant moves to dismiss under 3211A1, saying, wait a second, under Digipac, it has a merger clause. It supersedes any and all oral agreements. I don't recognize the oral agreement. At that point, the Supreme Court grants the motion to dismiss, says the merger clause was valid. It erased the obligations in the oral agreement. It merged into that written amended agreement. The plaintiff appeals, it goes to the appellate division, and they affirm what the Supreme Court had done. Because under Delaware law, which is the choice of law provision in the LLC of Digipac, written agreements are honored. Defendant had the authority to do this, and he did it. It appeals to the Court of Appeals, and here the question is, was the oral agreement, even though the complaint alleges it's between two, he's suing the defendant in his personal capacity, is that merged into the written agreement, the amended LLC? And the Court of Appeals says, yes, it is. The plaintiff does not recover here. Why? They say that under Delaware courts, applying Delaware law, if the terms are unambiguous, the LLC agreement should be interpreted according to its plain meaning. And in this case, the plain meaning is that the merger clause says the oral agreements are merged into the written agreement. There is no more oral agreement between the plaintiff and the defendant. It's not recognized anymore. Delaware law is very strong on this. This is why people create companies in Delaware. It gives a lot of power to the companies and their agreements. So because the amended LLC agreement merger clause unambiguously nullified the prior oral agreement between the plaintiff and the defendant has conclusively established a defense to the plaintiff's claimed breach of contract as a matter of law. So the dismissal is affirmed. This is a 4-3 decision. There is a 3-judge dissent by Judge Rivera, Wilson, and Troutman, who says it was a personal capacity in the complaint. It's different subject matter. It does not merge. But once again, the holding here is that it does merge. They caution that, and they say, Delaware cautions, if you're going to make a deal with a company, you better read all the fine print and know what you're getting into. That's the case of Baylor versus Tao. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.